Rule 11. This is heavily tested. Okay, so here's our rule script for Rule 11. 1, the signature requirement. Every pleading, written motion, and other paper must be signed by at least one attorney of record or by the party personally if they're unrepresented. That is the easy part. We know it. Every pleading, written motion, and other paper must be signed by the attorney or if they're unrepresented by the pro se litigant. Okay, here's the exception to the rule that gets tested. There's no requirement that a pleading be verified, meaning it's notarized or it's accompanied by an affidavit. Unless there is some law that states that you have to file a verified pleading. One example would be an injunction. But if one side files a verified pleading, the other side has to respond with a verified pleading. So Part A covers the signature requirement, but it also covers the verification. What is verification? That's right, it is notarized or there's an affidavit. Okay, and if one side files a verified pleading, what does the other side have to do? That's right, they must respond with a verified pleading. Okay, let's talk about Part B. And this is the easy stuff to memorize. By presenting to the court, the attorney certifies by signature. By presenting that signed pleading to the court, the attorney certifies that to the best of their knowledge, information, and belief formed under an inquiry, that's right, reasonable under the circumstances. Let's memorize this verbatim. To the best of the person's 1, knowledge, 2, information, 3, belief, formed after an inquiry that is reasonable under the circumstances. That it is 1, not being presented for any, improper purpose, such as to, harass, delay, needlessly increase the cost of litigation. Okay, let's repeat that whole thing. To the best of the person's knowledge, information, and belief formed after, that's right, an inquiry reasonable under the circumstances. It is not being presented for any, that's right, improper purpose, such as to harass, delay, increase the cost of litigation. Part 2, the claims, defenses, and other legal contentions are warranted by existing law or by a non-frivolous argument for extending, modifying, or reversing existing law or for establishing new law. We're going to memorize this verbatim. To the best of the person's, that's right, knowledge and information belief formed after an inquiry reasonable, that's right, under the circumstances, it is not being presented for any, that's right, improper purpose, such as to, that's right, harass, delay, needlessly increase the cost of litigation. Part 2, the claims, the defenses, and other legal contentions are warranted by what? Existing law, or by a, what kind of argument? That's right, a non-frivolous argument for doing what? Extending, modifying, reversing, or establishing new law. The what? Claims, 2, defenses, and other legal contentions are warranted by existing law or by a non-frivolous argument for doing what? Extending, modifying or reversing existing law, or for establishing new law. Part 3, the factual contentions have, that's right, evidentiary support or will likely have evidentiary support after a reasonable opportunity for investigation or discovery. Okay, the rule verbatim is the factual contentions have evidentiary support or, if specifically so identified, will likely have evidentiary support after a reasonable opportunity for further investigation or discovery. Don't simplify this rule. The factual contentions have evidentiary support, or don't forget, if specifically, that's right, so identified, if specifically so identified, will likely have what? Evidentiary support after, that's right, a reasonable opportunity for what? Not just discovery, further investigation or discovery. And for the denials of factual contentions are warranted on what? The evidence. Or if, don't forget it, specifically so identified, are reasonably believed based on belief or lack of information. Okay, let's simplify this a little bit and then we're going to memorize it verbatim. Okay, signature requirement, we know it. Doesn't need to be verified, but if one side files it verified, the other side has to respond with verified pleading. Okay, representations to the court. Knowledge, information, and belief formed after an inquiry that is what? Reasonable under the circumstances that one, not presented for any improper purpose, such as to harass, delay, or needlessly increase the cost of litigation. 2, the claims, defenses, and legal contentions. Part 2 covers legal contentions. The claims, defenses, and legal contentions are warranted by what? Existing law or by a non-frivolous. It's not a good faith argument. It is a non-frivolous argument for doing what? Extending, modifying, or reversing existing law or establishing new law. Now we get to the factual contentions. The factual contentions have what? Evidentiary support, or if, that's right, specifically so identified, will likely have evidentiary support after a what? Reasonable opportunity for what? Further investigation or discovery. Finally, part 4, the denials of factual contentions are warranted on what? The evidence, or if, that's right, specifically so identified, are reasonably based on belief or lack of information. Okay, moving on to sanctions. Okay, if after notice and a reasonable opportunity to respond, the attorney or the unrepresented party gets notice and a reasonable opportunity to respond, do they get a hearing? No, they get notice and a reasonable opportunity to respond. This could be a hearing. It could not be a hearing. They just need what? Notice and a reasonable opportunity to respond. If the court determines that Rule 11 has been violated, who can they impose sanctions on? Any attorney, any law firm, or any party. Don't forget, the party that violated the rule or is responsible for the violation. They can impose a sanction on the attorney, the law firm or the party that violated the rule or is responsible for violation. Notice, reasonable opportunity to respond. They can impose an appropriate sanction on the attorney, 2, law firm, or 3, party. Okay, and of course, law firms are jointly responsible. And what is an appropriate sanction? Our legal standard is what suffices to deter repetition. Okay, this could include monetary or non-monetary sanctions. Then, of course, we have our safe harbor. This is something we know well. Motion for sanctions, you make it separately, you serve it on the other side, you say, correct this, you give them 21 days, and if they don't, then you can serve your motion for sanctions. Okay. On its own, can the court issue a show cause order? Yes, it can. The court can sanction on its own, and on its own, the court may order an attorney, a law firm, or yes, a party to show cause why this conduct that is specifically described in the order has not violated Rule 11. On its own, the court may order who? The attorney, the law firm, or a party to do what? Show cause why their conduct specifically described in the order has not violated Rule 11. Okay, now we get to the nature of sanctions. Our legal standard is what suffices to deter repetition of the conduct. But here's the other thing. Suffices to deter repetition of the conduct or comparable conduct by others similarly situated. So it's not just to deter repetition of that party's conduct, it's to deter comparable conduct by others similarly situated. And of course, non-monetary sanctions are okay, paying a penalty to the court is okay, or you can get reasonable attorney's fees and other expenses awarded if they are imposed on what? Motion and warranted for effective deterrence. Okay, so this is a limitation on the award of attorney's fees and other expenses. They have to be imposed. If we're going to sanction someone with money damages, it has to be imposed on motion. Excuse me, if we're going to sanction someone for attorney's fees and expenses, it has to be imposed on motion and warranted for effective deterrence. Okay, when can the court not impose a monetary sanction? A represented party can't be sanctioned with money, a monetary sanction. Okay, finally, when the court orders a sanction, and it just say, dude, you're sanctioned. No, it must, 1, describe the sanctioned conduct and explain the basis for the sanction. You can't sanction a represented party with a money sanction. And when we have the order, it has to describe and explain. Describe and explain. Describe the conduct, explain the basis. And does this rule apply to discovery? No. Discovery is covered under Rule 26 through 37. And that is Rule 11.